Hello and welcome everyone to the Drishti IAS English YouTube channel. My name is Pragya and firstly I would like to wish you all a very happy and a prosperous Diwali. Stay safe and stay healthy. Okay, and this wish itself forms the background of our today's discussion. We are going to discuss today our fundamental right to clean air, because we all know that we are reeling under severe air pollution as of now. So we are going to discuss how we have been ensured a fundamental right to clean air under Article 21 of our Indian Constitution, and how Supreme Court is playing a very proactive role in this regard. In this discussion, we are going to study about the constitutional right of clean and healthy environment. We are also going to see the environmental protection laws in India, and we are also going to analyze the role of judiciary in protecting our fundamental right to clean air and healthy environment. And in the end, we are going to discuss a practice question for your prelims examination and a practice question for your mains examination. So if I talk about the background of our today's topic, recently it has been observed by the Supreme Court that air pollution is a murder of public health. The Supreme Court has made stern remarks in the Delhi's air pollution case, and it has said that we need to, ramp up our speed, ramp up our actions, affirmative actions to curb air pollution. So we have a fundamental right to clean and healthy environment under Article 21 of our Indian Constitution, as I have mentioned to you before. This fundamental right to clean air and healthy environment is also a declaration of human right, a basic human right, and it was declared as a human right in the Stockholm Conference. Stockholm Conference, which is also known as the Magna Carta of Human Rights. Okay, so we have a very basic human right to clean air, to breathe clean air, to survive in a healthy environment. But see what is happening. We are reeling under air pollution. So if I talk about the fundamental right to clean air and healthy environment, the Constitution of India did not include provisions related to the protection and preservation of the environment at the very first place. So we did not have this provision. This provision was added as a provision under Article 21 by the help of judicial intervention, judicial activism, the proactive approach of the Supreme Court. So the Supreme Court has interpreted Article 21, and the Supreme Court always has said that a right to life does not mean a mere animalistic existence. You need to have a dignified life, okay, and this dignified life also includes right to be in a clean environment and to breathe clean air. Okay, now let us discuss the constitutional provisions in this regard. So, Article 48A, which forms a part of the directive principles of the state policy, states that the state has a right to give you, has an obligation to give you protection of natural environment, a free environment, a clean environment, as well as the state shall also ensure protection of wildlife resources, forest resources. So this is a directive principle of the state policy, and the state is obligated to give you a clean environment, a natural environment, okay, as well as we as a citizens also have a fundamental duty under Article 51 Clause A, Subclause G, to protect our natural environment, wildlife resources and forest resources. So the state is also obligated to give you natural environment, and if this natural environment is given to you, then you have a fundamental duty to protect it as well. So these constitutional provisions talk about our right to clean environment and to breathe clean air. Not only this, even some sections of the Indian Penal Code penalize you for, destroying the environment or violating the environment. So we can say that we do have a right to stay in a clean environment and to breathe clean air. Okay, now let us discuss the environmental protection laws in India and how the state is ensuring that our natural environment is protected. So the first and the very foremost law is the Wildlife Protection Act of 1972. This Wildlife Protection Act is very important to preserve the wildlife in India. Okay, then comes the Water Prevention and Control of Pollution Act of 1974. It talks about mitigation and curbing the water pollution. Then comes the Forest Conservation Act of 1989, which talks about protecting our forests, especially those forests which are marked as dense forest or important forests. Okay, so the state has a duty, and anyone in violation of the provisions of these acts will be prosecuted. Okay, then comes the Air Prevention and Control of Pollution Act of 1981, a very important legislation which guarantees that we will be having a right to breathe in clean air. It talks about basically mitigating the air pollution. Okay, then there is the Environmental Protection Act of 1986. This is also known as the Magna Carta of environmental laws in India, because this act is very wide in scope. It covers all of the environmental legislations in them, and it also penalizes for violating the environment. So this is known as the Magna Carta of environmental law, because it discusses and tries to protect the environment as a whole. Then comes the National Green Tribunal Act 2010, which has established the National Green Tribunal in India. This tribunal is very important to enforce environmental laws in India. So not only the Supreme Court is playing a very proactive approach. If you talk about NGT as well, NGT also has given many landmark cases and judgments which protect our environment. Okay, so now let us discuss some of the environmental concepts evolved by our Indian judiciary and the role of Indian judiciary in protecting our environment. See, we follow a doctrine of separation of powers in India. That means the Supreme Court cannot, intervene in the function of the legislature and executive. But this doctrine of separation of power does not mean we have put legislature, executive and judiciary in watertight compartments. When the time arises, when the judiciary is seeing that the legislature and the executive are not following their duty, it cannot be a mute spectator, right? It has to intervene, and hence the judiciary is empowered to intervene in those circumstances where the legislature and the executive are not performing their duties well. Okay, so to fill the gap left by the legislature and executive, the judiciary often intervenes. And judiciary in India, the Supreme Court in India, is a protector of our fundamental rights, and that is why also the Supreme Court intervenes wherever there is a violation of our fundamental rights, and sometimes it does on its own motion, that is suo motu. Okay, so the Supreme Court in India has protected our fundamental right to be in clean environment and to breathe clean air time to time. So let us see some of the landmark cases and the decisions given by the Supreme Court to protect our environment. Okay, so the first case is Indian Council for Environmental Legal Action versus Union of India 1996. This is a landmark case in which the Supreme Court has evolved the polluter pays doctrine. Polluter pays doctrine or principle. So what happened in this case was a factory was established in a small village in Rajasthan, and due to the industrial waste, the soil got polluted, the water got polluted, there was agricultural loss. So this NGO in Indian Council for Environmental Legal Action filed a PIL in the Supreme Court asking the Supreme Court to intervene because there was a loss of environment in that small village in Rajasthan. And the Supreme Court evolved the very famous doctrine of polluter pays principle in this case. The Supreme Court said that if you are polluting the environment as an entity, you will make good the loss that is caused by the environment. So the one who pollutes will pay the costs. This is known as the polluter pays principle or polluter pays doctrine that was evolved by the Supreme Court in this case. Okay, then comes the landmark case of MC Mehta versus Kamal Nath and others. MC Mehta is a pioneer in PIL and as well as a very important environmentalist and activists in India. So the Supreme Court in this case took cognizance on an Indian Express newspaper report. What has happened was Mr. Kamal Nath came in power and he wanted to build his huge mansion on River Bees. The Supreme Court took cognizance of the Indian Express newspaper report about this mention, and the Supreme Court said that an individual cannot be allowed to, play with the environment. And if he does so, then the Supreme Court in this case said that the doctrine of public trust. Doctrine of public trust. So the Supreme Court categorically said that doctrine of public trust is applicable in India, and whoever is, violating the environment, whoever is causing loss to environment will be liable to make good the loss. So there is this doctrine of public trust. The public has imposed trust in you to protect the environment. So as an individual also you cannot violate the environment, or you cannot cause loss to the environment. So the Supreme Court evolved a very famous doctrine and said that the doctrine of public trust is applicable in India. Then comes another landmark case of MC Mehta versus Union of India, 1987. This case came after the Bhopal gas tragedy case which we experienced in 1984. So the environment was also, very dark at that point of time. We were already reeling under the aftermath of the Bhopal gas tragedy, and then this case happened. What happened was, in this case, there was a leakage of oleum gas from the plant of Shriram Food and Fertilizers, and the Supreme Court in this case evolved the very famous doctrine of absolute liability. Just a second. Absolute liability. So this is in contrast to the principle of strict liability, which we used to follow under the English law or law of torts. Strict liability. The doctrine of strict liability states that whoever brings into his or her premises a thing which is inherently dangerous in nature, and if that thing causes some damage, then that person would be liable. But this doctrine of strict liability had some exceptions. But the Supreme Court in this case, that is known as the oleum gas leak case or MC Mehta versus Union of India case, evolved the Indian version of this strict liability doctrine, also known as the absolute liability doctrine. The Supreme Court clearly said that this doctrine has exceptions, and these exceptions cannot be allowed in India. Indian circumstances are different. So the Supreme Court said that if you are bringing a thing that is inherently dangerous in your premises, and if that thing leaks and causes damage or causes some natural hazard, then you will have no exceptions in your defense. You will be absolutely liable. And this is the doctrine of absolute liability, which was evolved by our Honorable Supreme Court in the MC Mehta versus Union of India case. So with this, we come to a conclusion of our today's discussion. We have seen that how we are having a constitutional, responsibility to protect our environment, how we are having a fundamental right to be in a clean environment and to breathe clean air, and how judiciary as a protector of fundamental rights is ensuring that we have a right to clean environment, and our right to clean air, breathe clean air is protected. So judiciary indeed is playing a very proactive role. And in the Delhi pollution case also, the Supreme Court has made very stern remarks that you cannot murder public health like this. You cannot, keep on making this issue of air pollution as a political battle. We cannot let this happen to the health of the public. So the Supreme Court is playing a very important role in protecting your fundamental right to clean environment and to breathe clean air. Okay, now let us discuss a practice question for your prelims examination. So the question is, consider the following statements. Your statement number 1 is, right to clean air is a fundamental right under Article 21 of our Indian Constitution. Your statement number 2 is, Article 48A casts a duty on the state to protect the environment. Which of the following statements given above are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. Kindly drop your answers in the comment box below. Now let us discuss a practice question for your mains examination. So the question is, discuss the role of judiciary in protecting the fundamental right to clean air. Firstly, you will write that we have a fundamental right to clean air and to be in a clean environment under Article 21 of our Indian Constitution. You will discuss the role of judiciary, as I have discussed in my discussion today, that three famous principles of environmental laws have been, evolved through judicial activism or proactive role of judiciary. The polluter praise principle, the doctrine of public trust, which is applicable in India as well, and the concept of absolute liability. You will also write the Supreme Court's rule in the current Delhi pollution case data that is happening. The Supreme Court is asking the states to tackle the air pollution effectively, and the Supreme Court has also reprimanded the states about not being able to tackle the air pollution. The Supreme Court has also asked the states to report to the Supreme Court about the measures they are taking to control the air pollution that is happening currently in North India. Okay, so you will write all of this and you will say that Supreme Court, in your conclusion you can say that the Supreme Court has to intervene wherever there is a void left by legislature and executive, and the Supreme Court, being the protector of our fundamental rights, plays a very important role in ensuring that our fundamental rights are not violated. So you can conclude holistically. Okay, I hope this session was insightful for you. I would also like to take this opportunity to inform you about our special discount 50% off that is going on from 10th to 14th November. So you can avail a 50% discount on our online courses on the Drishti Learning app. Okay, and you can take this offer. It will be very beneficial in your preparation. So not only the test series and etc., but the discount is also going on the GS Foundation course. So kindly take good, take this opportunity to avail a 50% off and to boost up your preparation. If you like the today's discussion, kindly like the video and subscribe to our channel for more such updates. Thank you.